Good afternoon and welcome to the Law and Crime Report. I'm Angelica Spanos. Thanks for joining us today. The show where we dive into today's top legal and true crime headlines. First up, the ex-Louisville police officer Brett Hankison, who was charged in relation to Breonna Taylor's death once his trial moved venues. His attorney says that they want the trial in another county in Kentucky. You'll recall that the 26-year-old Breonna Taylor was shot and killed during a raid at her apartment on March 13th. This was after officers with a no-knock warrant broke her door down looking for evidence in a narcotics investigation. Here's the Attorney General announcing the charges against the then officer Hankison.
With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankison for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire.
All right, so that's the Attorney General there talking about the charges that they brought on to Hankison. He was charged with first-degree wanton endangerment. This was after bullets went into a neighboring apartment during the raid. He was also charged with a few other things there. But I want to introduce our guests now. Today joining us, Matt Mangino, Law and Crime Analyst, as well as Dina, Law and Crime Analyst. Thank you both for being here today. Matt, coming out to you first, what do you think? What's your reaction to Hankison's attorney filing this motion to begin with?
Well, I mean, it's not unusual in a case in which there's been a lot of pretrial publicity to seek a change of venue. And there's been a lot of news accounts locally and nationally with regard to this case. But often, you know, what a trial judge attempts to do is find out first if he or she can, in fact, seat a jury. So the voir dire process may begin in this case. And after they go through a series of potential jurors and find that they're unable or may be unable to seat an impartial jury, then the case would be stopped at that point and possibly either moved to another county or bring potential jurors in from another county to hear the case.
All right. So, Dina, as Matt said, this has received a lot of national attention. He obviously wants to change the venue here in fear that he wouldn't be able to get a fair trial just because of this attention and mainly negative attention that he's received. Do you agree? Do you think that it would be hard for him to get a fair trial in the current geographic area where the trial is set to be held as of now?
I think he could get as fair of a trial there as he can anywhere in this country. This reminds me of the George Floyd case where the judge denied moving it, and also Harvey Weinstein. Both of those cases had national attention. And with the kind of publicity we see now, there's really nobody in the United States who hasn't heard of these kind of high-profile publicities. So county to county really doesn't really help that much. But the reason why the defense files these motions is to preserve the appeal. So if he were to be convicted, this is something they will appeal. The fact that this was denied, and possibly an appellate court could agree that the judge should have allowed it. But I don't see the judge actually allowing it here because of the fact that this kind of publicity is everywhere, and it's not going to make much of a difference if they change it to another county.
All right. And as of right now, we know that the trial is set for August 31st. That does give, I guess, several months for this decision to be made. Do you think that this is a decision that the judge here quickly? Some will take some time if and when we do find out what happens with this, Dina.
You know, it really depends on the judge's calendar, and he may have kind of already said when to expect to hear a hearing, but this is not a complicated decision on his part. So we could see something fairly quickly, and I guess a denial of this motion.
Dina, thank you. Right now, as I said, we know the trial is set for the end of August. Hankison's legal counsel is saying that he's asking for this change because of the negative attention the case has received. Here's a clip from the hearing. This happened this week. We only have the audio. Take a listen.
I do intend to file at some point a petition to change the venue of the trial. And I don't know how the court would plan to proceed on handling that.
Well, I think we would have to schedule a hearing once you file that motion. Do you know when
Yes.
you'll be filing? Do you know when you'll be filing that, Mr. Matthews?
Well, I was kind of waiting to see what we did today as far as what we're talking about in terms of scheduling a trial.
Okay. Well, obviously with COVID, it makes it a little bit more difficult to know. I know that the Chief Justice has said in one of the more recent orders from the Supreme Court that we should be able to start trying cases in April. Now that date has been changed a couple of times with the Supreme Court's orders. I'm not terribly optimistic that this spring is going to be able to, that we'll be able to actually have trials. But you all can tell me when you think you would want me to start looking for a trial date. And Ms. Whaley, could you possibly, if you could, give me an idea of how long you think the prosecution's case would take to try?
Excluding jury selection.
That's fine.
I would anticipate 3 to 4 days for the Commonwealth's case.
All right. So there you heard the attorney asking for the change of venue there. Matt, state law there in Kentucky allows the jury to be removed if it appears that the defendant or the state cannot have a fair trial in the county where the prosecution is pending. Based off that, and that is, again, the Kentucky rule there, do you think that this judge will allow this or not?
Well, what I think is important about a change of venue is that it doesn't necessarily matter whether or not the potential juror heard something about this case or knows something about this case. What's important is whether or not what they know or what they've heard could somehow impact their ability to be a fair and impartial juror. So just because you've read about the case, you saw it on television, and I'm sure most people in the Louisville area have heard about this, have read about it, have seen something on television. But what you've heard, what you've seen, what you've read, does it impact your ability to be a fair and impartial juror? And that's the fundamental issue here. So the only way to really determine that would be to begin voir dire, begin to interview jurors. And if you find that you can seat a number of jurors as the process goes along, and that you might be able to put a complete jury together who can be fair and impartial, then you proceed with trial there. If you find during that process that you can't seat jurors, then it's time for that case to move either to another county or bring a panel in from another county.
Absolutely. And it seems with something that just got so much national attention as this, as well as it coming and happening during a nationwide sort of movement based off this incident, that it would be hard to find someone in that area who hadn't heard of this. But as you said, it depends on if they'd still be able to be a fair juror in this, not if they necessarily know or heard anything about the trial. And Dina, you touched on that earlier, because when we look at other national cases and trials we followed, Harvey Weinstein, for example, this is always the case. It's really hard to find someone who has no idea about an incident this big, right, Dina?
Right, exactly. Because the whole reason of this is that the community is so, maybe upset about what happened in that particular community that they have to move it. But because of the publicity, probably every community has people that are upset because this happened. And that's why moving the trial just because there was a lot of doesn't actually help the defendant when it's a national public trial like this, because you're going to have a group of people in every community that you find in this country who heard about it and had an opinion. So yes, is Louisville really going to be any different from the next county? Probably not. You only have to find 12 people. You only have to find 12 people who are impartial despite the fact that they heard it.
Dina, Matt, thank you both. We're going to take our first break right now during the Law and Crime Record. We'll be back after this. Stay with us.
So let me talk a little bit about why I believe that there's a need to reverse the guilt phase as well. And it's a relatively simple Eighth Amendment argument that depends on two principles. The first is that effective group deliberation is essential to reach a reliable guilt phase verdict. There's not much dispute about that. The second is that in a series of cases, the United States Supreme Court has made clear that the Eighth Amendment does not permit procedures which undercut reliability. Now, before I put these two together, I want to concede something. The defendant is not entitled to a jury of 12 people that are all skeptical about the death penalty and that may harbor a pro-defense bias and may harbor an anti-prosecution bias. But by the same token, neither is the prosecution entitled to a jury of 12 people that think the death penalty is swell and that harbor a pro-prosecution bias and an anti-defense bias. Reliability is best served when both groups are on the jury. Then there's the give and take that leads to a reliable verdict. And what happened here was the systematic exclusion of those jurors who were opposed to the death penalty but could consider death. And that removes a voice, a perspective from jury deliberations that I believe is essential to a reliable result. That's why I believe it's not foreclosed by precedent, and that's why I believe there is a Eighth Amendment violation as to the guilt phase.
And welcome back. That was Scott Peterson's defense attorney speaking about a jury issue during his jury trial. Peterson was convicted in 2004 for killing his pregnant wife, Lacey, and their unborn son, Connor. Now, it's likely now that in March 12th to be exact, that a judge will now make a decision on whether Peterson will be awarded a new trial for the guilt phase. If this new trial is granted, it means that new witnesses and new evidence would be used for this part of the trial. As you just saw, Peterson was seen via live stream in a hearing this week. That was from death row at a prison. I want to talk about this with our guests today, Matt Mangino and Dina. Matt, before we get into the details of why and why this is happening, talk to us about what exactly it means that this is a new trial for just the guilt phase.
Well, in a death penalty case, there are two phases to a trial. There's the guilt phase, where evidence is presented to determine whether or not, in fact, this person is guilty of first-degree murder. And then there's a penalty phase to determine whether or not this individual shall receive life in prison or the death penalty. And so what they're seeking is a new guilt phase, a new trial on the fundamental elements of first-degree murder. And it's interesting. This conviction was back in 2004. Scott Peterson had direct appeals, and now he's collaterally attacking his conviction through post-conviction relief. And in order to get a new trial or even to have a viable post-conviction claim, you have to suggest that there is after-discovered evidence that wasn't available to you in 2004 that's now available to you if there's a new trial. And that relates to the issue of the life or the actual time of death of the fetus. That's the new evidence in this case.
So based off that and what you said, do you think that he has a good case here for a new trial?
Well, as I understand it, there is a doctor who's really the only person who sort of holds this opinion that, in fact, the fetus's time of death was not what they would have projected it to be at the time of the 2000 trial, but approximately 10 days later. So obviously, what they've proven in terms of Scott Peterson's whereabouts and those sorts of things have no bearing if, in fact, the fetus was alive and the mother was alive for 10 additional days. So that puts their whole plan, their whole scheme that was presented in 2004, kind of throws it out the window, because now you have a time of death based on this expert's testimony, who seems to be the only expert who offers this kind of testimony, that in fact the death occurred 10 days later.
I'll come to you now. Do you agree with Matt here? I mean, do you think that this, I guess it's a doctor, I believe, that has this new protocol about the death of a stillborn? Do you think that this is good enough? Do you think this is heavy enough to even have this new guilt phase trial?
I don't think an expert alone is going to be enough. I mean, we always have competing experts at trial. And he, I'm sure, had an expert at the time talking about the timing of death and cause of death. And the fact that he now has somebody else who maybe is going to testify a little bit better for him, I don't think that's enough. But it seems like they're also arguing that one of the jurors that was seated lied about having been a victim of a crime and been involved in a lawsuit. And that, to me, is a stronger argument, because, that violates his due process. If somebody, he needs 12 impartial jurors. And if one of the jurors is lying on their, questionnaire or in open court about these specific questions, that is more possible for him to have a new trial as a result of that.
Do you think that this is just kind of a desperate effort to get him out of death row here? Or do you think this actually has any substantial weight to it? Dina?
Well, it's interesting, because he actually has two potentially new trials. He's going to have one. We know for sure he's going to have a new trial just based on whether or not he's going to receive the death penalty. The court has already said that they should have allowed jurors who were against the death penalty to still remain on the trial if they were willing to set aside their personal beliefs and be impartial. And because they didn't do that at the time, he's going to receive a new trial in terms of the sentencing. So he may not be on death row, kind of regardless of the guilt phase. But whether or not he gets a new guilt trial, that, like you said, we're not going to know that yet. And I think we have to know a little bit more about maybe what that past crime was. If it was a violent crime that juror was a victim of, that to me could very much allow him to have a new trial. But if we're talking about, some sort of misdemeanor type crime that really you could call it a crime, but maybe wouldn't affect that person's being impartial in this murder trial, then it wouldn't set aside. But it's very interesting here that now he actually has a chance to reopen both phases, which is very hard in post-conviction for any defendant to have either of these be reopened. We already know he has one, and now it's possibly two.
All right, Dina, thank you. Matt, thank you too. We're going to switch gears right now. Next topic of the day. Michelle Troconis, the former girlfriend of Fotis Dulos, has asked a Connecticut judge to toss out some charges connected to the disappearance of her boyfriend's former wife, Jennifer Dulos. We covered this story extensively. Troconis' attorney has now filed a motion that calls into question whether state police actually had probable cause to arrest her. She was charged with tampering with evidence and conspiracy to commit tampering with evidence. This is as police spent this week digging up a property of Dulos' building company looking for Jennifer's body. You'll remember that her body has still not been found. Dulos was charged with his estranged wife's murder, and he died by suicide back about a year ago, I believe in January of 2020. So this is still ongoing here. We have a police interview we want to show you when police interviewed the girlfriend, Michelle Troconis, here, as well as an update on the search when that was going on.
And then he walked and he grabbed me, he gave me a piece of paper over the toilet, the paper towel, and I put it inside where I had the bag of cleaning, what I was cleaning, the house.
Okay, did you see spilled coffee?
No, I didn't see that.
Did you see a coffee cup?
No, because I didn't look inside the car.
Did the paper towel smell like coffee?
No, I didn't smell
well,
it.
But still, you're holding that coffee stinks.
But I hold the paper towel, but I didn't smell it. I didn't see that.
But even still, you didn't smell coffee?
No.
You know how coffee is when you smell it, it stinks.
Yeah.
Smell it.
As many of you are aware, over the past day or so, our Western District Major Crime Squad detectives have been on the property, following up on leads and continuing to investigate the disappearance of Jennifer Dulos. Again, this investigation is still active and ongoing. At this point, we do not have any updates to provide to the public, and we do require or request that any updates moving forward or any requests for information moving forward be directed to the Chief State's Attorney's Office. That will be able to provide you with significant updates or significant updates to the investigation. And at this point, that's what we have to say regarding the investigation. Our main goal is to, again, work towards providing the family of Jennifer Dulos some closure, and our detectives will continue to work tirelessly in the direction of doing so. Thank you all.
All right, so Troconis' attorney is asking to throw out the allegations that she was helping in the conspiracy charge with this tampering with evidence and conspiracy to commit tampering with evidence. Now, this is interesting because reading through the filing, it says that basically there was video and traffic camera video that showed that the car that allegedly Fotis Dulos and Michelle were in showed a woman in the car in the passenger seat, but it didn't show her getting out of the car and helping him get rid of any garbage, this trash. So that is what they're pointing to in this filing. Matt, do they have a case here with that? And what do you make of this new motion?
Well, they're challenging the probable cause for an arrest warrant. They're challenging the probable cause for these charges to be filed. And while probable cause is a significant criminal standard, it merely means that more likely than not, a crime has been committed and that this individual committed the crime. And she's charged with tampering or destroying evidence. And they've alleged in this complaint that they stopped 30 times in a pickup truck to dispose of evidence that she was in that truck, although she never got out of the truck. The other issue was that it said in the affidavit of probable cause that she did not want to cooperate, when in fact, it was noted that she asked for an attorney, and you have the right to ask for an attorney if you're being subjected to a custodial interrogation. In fact, you should be advised that you have the right to an attorney once the custodial interrogation begins. So that might be, a little over the top, trying to suggest some guilt by asking for an attorney. But I don't know that this motion is going to be enough for the court to toss these charges. She's going to have her right to force the prosecution to prove beyond a reasonable doubt, which is a much higher standard, a much more difficult standard. And that's what her right is. So she's going to have her day in court. She's going to have her opportunity to sit there while the prosecution proves to this high standard beyond a reasonable doubt that she, in fact, tampered with or destroyed evidence.
All right, Matt, thank you. And Dina, this is all happening as this past week, police were on one of the properties of Dulos's building company looking for her body. And that's interesting because one of the main parts of this is we still haven't found her body. So do you think that the timing of this is a little off, if you will, Dina?
Yeah, that's interesting. I imagine they've been preparing this filing for a while, but it's possible that they kind of decided to file it quickly, not knowing what was going to come. I have to say that, I think we need to hold police officers to a high standard in terms of what they say to the court. It reminds me a lot of the Breonna Taylor situation, where they obtained a search warrant because they were also misleading in their warrant, and that resulted in a death. And I think that officer should be charged in that. And I think it is here also. We can't pick and choose when we want the police officers to be honest to the court. He is really making that affidavit under penalty of perjury. And so he needs to be as honest as any other witness on the stand in a trial. If a witness on a trial after taking an oath were to lie in open court, we would say how horrible that is.
Right.
We need that police officer's statements to be taken to as rigorous of a standard. I actually think if it is true that they did lie this way, then I would agree to throwing out the rest of the evidence. It seems like a really intense measure, but perhaps we need to really hold these officers to such a strict standard that they will be a lot more careful and a lot more honest in their affidavit.
All right, Dina, Matt, thank you both. We got to hit a break right now. When we come back, plenty more of today's top headlines. Stay with us after this.
I'm Eric Love, a former law enforcement officer turned businessman and private investigator. We built an army of attorneys to assist in the appeals process and right this monumental injustice.
With this extensive support, this unit intends to prove that the Tiger King is not only not guilty, rather, he is the victim.
And welcome back. That was the star of the Netflix series Tiger King. Joe Exotic, well, he was let down big time on the last day of President Trump's time in office. He was so sure that he was going to get a presidential pardon that Joe Exotic had booked a limo to sit outside of his Texas prison, ready to take him away as he is serving a 22-year sentence. Well, that didn't happen. The embattled zoo operator was very disappointed when he was excluded from the list of pardons that came from President Trump. Exotic was convicted in April of 2019 on federal charges of animal cruelty and attempting to hire a hitman. to kill his rival, Carol Baskin. He had some choice words for the former president. He said that his sexuality may have played a factor in Trump's decision. He said that he was, quote, too innocent and too gay to deserve a pardon from President Trump. Matt Mangino, Dina with us. Dina, coming out to you first. What do you think of this? I mean, no matter what, gay or not, I hate to say it, but I think Joe Exotic is going to have to serve out that sentence. I don't think it had to do anything with his sexuality.
No, I agree. If anything, I think it was because he was too yesterday's news. I mean, if his series had come out in December, I think that would have been more likely. You know, Donald Trump did ask, I think, a CNN reporter at the time in a press conference, "Oh, should I pardon him?" He was interested in the case, but a lot has happened since then.
Absolutely, and yeah, to go off that, I think a reporter asked hey, are you going to pardon the Tiger King? And he said, I have to take a look at that case. And of course, we then learned after that Exotic had sent a handwritten letter to Trump arguing that he didn't get a fair trial when he was convicted. And he did indeed request a pardon from the then president. Matt, what do you think of this story?
Joe Exotic is not the first person to be disappointed by President Trump. President Trump, he granted pardons and clemency to a whole list of people, a lot of them high-profile people like Steve Bannon or Paul Manafort or Roger Stone, and even people like Lil Wayne got a pardon from the president on his way out the door, but not Joe Exotic. And I think you're right when you say, hey, he's just not, he's not a hot commodity anymore. He's been in jail. He's been convicted. He's run his route in terms of, television stardom. And there was nothing to be gained or won by President Trump on his way out the door, pardoning the Tiger King.
All right, no pardon for Joe Exotic. We will be keeping up with him to see what else comes out of his prison sentence there. Moving on, a Pennsylvania woman facing charges after helping to steal Nancy Pelosi's laptop during the attack on the U.S. Capitol was freed from jail. The 22-year-old Riley June Williams was released into the custody of her mother with travel restrictions and instructed her to appear in federal court in Washington connected to her case. She's accused of theft, obstruction, and trespassing, and violent entry and disorderly conduct on the grounds of the U.S. Capitol. She has no prior record. The unidentified former boyfriend of Williams apparently tipped off the FBI to her after seeing her in those videos. So this is another interesting story here. Obviously, big topic of conversation as of late. But my question to you, Dina, is why was she released? And now that she's going to be going to federal court in Washington, what do you think will happen when she faces a judge there?
Well, she was released with an ankle monitor, and she has to remain in the home of her mother. So essentially, which is common. Commonly, this happens before somebody actually, is awaiting trial. But I think it's interesting. You noted the charges on there. I wonder if, she goes along in their investigations and their charges, whether or not felony murder will be added here. Because the federal murder rule is very restrictive, and you have to have committed one specific underlying crime, but one of them is robbery. And she did steal this laptop, and it sounds like her boyfriend made it sound like there was an intention to steal this laptop and possibly sell it to the Russian government. So she seems to be one of the people who were involved in the riots that day that could actually be charged with felony murder.
And when looking at this, we know that in this case, we're talking about a laptop. There were other perpetrators there that day who stole pieces of furniture. Most, imagely famous is the person who stole that podium lectern thing. So So I guess my question is, does the laptop and potentially it having contents on it that are much more significant than a piece of furniture, does that matter that it was the laptop in this case, Matt?
Well, I don't know that it necessarily matters. I mean, when you look at, for instance, thefts, you look at the value of the item that was taken. Whether or not Dina makes a good point, whether or not this is actually a robbery, was this taken by force, or is this a theft? Is it a felony? So those are all factors that the U.S. attorney would have to look into. Obviously, she's not charged with anything with regard to the laptop at this point. But I think the thing that's most telling about Riley Williams is just how she got involved in this. She was kind of an anonymous high school student. She's living with her mother. She's working in the healthcare services industry. And I read an interview with her mother where she said, recently she's become very involved in politics, and particularly Republican politics, and reading and being involved in what's going on the internet. It's almost cult-like, so you take this sort of unassuming young woman from Harrisburg, Pennsylvania, and all of a sudden she's enthralled by the rhetoric of the president and other supporters, and there she is in the Capitol during an insurrection, directing people up the steps to go to the Speaker of the House's office. It's really a telling story of Riley Williams that I think needs to be closely looked at, because I think some of these people were sort of gobbled up into this movement, and may well have done things that they never dreamed they would have done 6 months ago or a year ago. But here we are.
All right, Matt, Dina, thank you both. Another break right now on the Law and Crime Report. When we come back, one more story for our show. Stay with us. Welcome back. A Nevada man known as the Black Widower had his double murder conviction overturned last week. 4 of his 6 past wives have all died. He was convicted of murdering his 6th wife and a man who allegedly paid to kill her in 2017. He was sentenced to death for the killings, but has been fighting for it ever since. The 65-year-old will now stand trial again and remains in custody until the new trial. Here is a recap of this from our own Anjanette Levy of Law and Crime.
Yeah, Brian, Thomas Randolph was sentenced to death for the 2008 murder of his wife, Sharon. He says he is stone cold innocent. The Killer Genes podcast is brand new, and it takes a deep dive into the case.
My wife's been shot, and there's a guy in my house, and I shot him.
Prosecutors say that 911 call was staged and that Thomas Randolph paid a hitman to kill his wife, Sharon, in 2008 to collect life insurance money, and then killed the hitman. Randolph's been talking to Melissa McCarty and Kelly McLear, creators of the Killer Genes podcast.
I've been talking to this man for 3 years, and he has never wavered in his stance that he is an innocent man. And we're not here to say whether he's guilty or innocent, but it is someone that prosecutors are calling a socio and psychopath.
Randolph has been dubbed the Black Widower. He's been married 6 times. 4 of his wives are dead, including Becky, who died in Utah in 1986. Randolph was acquitted of her murder. Prosecutors discussed that at his trial for Sharon's murder, and that's why he's getting a new trial.
Is Thomas Randolph just a guy who is completely unlucky in his love and his marriages and just seems to always be in the wrong place at the wrong time? Or is this man a genuine serial killer and a psycho and sociopath?
And that's the question these podcasters are trying to answer. I contacted the Clark County District Attorney's Office for an interview. My request for that interview was declined, and I was also told there would be no comment. Thomas Randolph is going to be in a Nevada courtroom later this week. Brian.
As I understand it, this is a 2-part podcast, so Thomas Randolph had a lot to say.
Yeah, that was the interesting part of this interview. They said that he had a lot to say all of the time. He talked to them quite a bit, and it was very unfiltered. They said he has an answer for everything, and he actually admitted to being a serial cheater, but he says he is not a wife killer. So that part was very interesting. And I should mention that Randolph's daughter actually told the podcasters that she is very glad that her father is getting a new trial. But Sharon Randolph's daughter said that she believes he is guilty and that she will be in the courtroom each day of that new trial.
All right. So basically, the Black widower here was granted a new trial because they're arguing that the Supreme Court or the jury in his trial should have never been able to hear the fact that he collected money from a life insurance policy about from the wife that she had taken out. So this is interesting because I guess the salacious thing about this is 4 of his 6 past wives have all died. Matt, reaction to this and the fact that he is going to get a new trial?
Well, it's always a risk when prosecutors use prior bad acts in a trial to try to prove that, in fact, the defendant is guilty of the crime that he's been accused of. So if you use information from a 1986 acquittal, or you use information, from other witnesses about his sort of mode of operation, this is his 6th wife now that he's accused of killing. 4 of them have died. That's always a risk. And defense attorneys always know that it's very, very, very prejudicial to bring up prior bad acts during a trial for your client, because obviously once the jury hears, well, he did something similar before, or he was accused of something similar, the chances they're going to find him guilty go way up. So that was the risk the prosecution took, instead of just presenting the evidence that they had in this case only. And now they're going to have to do it again. And as a former prosecutor, that was always one of my concerns. I didn't want to try the same case twice. I wanted to make sure, even if I went out of my way, that there were no errors. So in fact, I wouldn't be back now trying this same case years later.
All right. And Dina, in about a minute, your reaction to this?
At least he is getting a new trial. We should remember that. He's not being set out free. So they are going to have another chance to, one, prosecute him and to defend him. The fact is, we have this rule called double jeopardy in this country. And he was stood trial for that alleged murder and was found innocent. And the Supreme Court here found that it was too prejudicial to bring that in because he was already, sort of cleared his name, so to speak, in that. This could have, I think, gone either way. We see often prior bad acts being brought into court. But like I said, he's not being set free. We have a new trial, and they do get a chance to convict him, just based on his acts relating to this murder.
All right. Dina Dahl, Matt Mangino, thank you both for joining us today on the Law and Crime Report. A new trial for the Black widower has not been set, so I do want to add that. We will have to see what happens with this overturning, and of course, we will keep you posted on that. In the meantime, I want to direct you to our regularly scheduled programming. And again, thank you all for joining us today on the Law and Crime Report. Have a wonderful Friday.